the hearing in this matter. I'm actually gonna, I don't know. Hold on. Oh, get this. All right. So, I have received a copy of. I have received a copy of a report dated August 12th of 2025, signed by Aaron Resney, licensed psychologist, consulting forensic examiner, and you'll see that Arnold Mr. Mott.
Yes, Your Honor.
Excellent. I've also received People's Exhibit 1, which is, well, they're all People's Exhibit 1 for each file. So I have People's Exhibit 1 on each file, which is felony information, and a copy of police report for each file. You received those, Mr. Moore.
Yes, Your Honor.
Okay, very good. So, Ms. Arnold, you people see this, the word place on the record. He is, no, you don't believe, okay. So, Ms. Arnold stipulated to entry of the report dated August 12th, 25 regarding cops stand trial.
We do, Your Honor.
Mr. Mott, do you stipulate to entry of that report as well?
Yes, Your Honor.
Okay. All right. Should I review that report then?
Okay.
All right, and then the findings on that report. Okay. So, Mr. Burke was evaluated on August 12th of 2025. He's a 33-year-old man born on 14th. He was charged with home invasion, first degree, second degree arson, assault with a dangerous weapon, jail's possession of a weapon, and assault of a prison employee, and counts of police officer assaulting, resisting, obstructing. Some files that he is currently before us. Was it request by the defense for an examination regarding competency, and Mr. Burke was properly engaged in the evaluation according to Dr. Resney. There was no behavior indicative of intellectual disability or other cognitive, psychological, or psychiatric issues that impeded his capacity. In the doctor's opinion, Mr. Burke was aware of the accusations against him, how they arose, considered his defense actions reasonable expectations. Mr. Burke understood how the court works, the role of primary legal counsel, defense actions, possible outcomes, and clearly was able to voice concerns. And Dr. Resney found that in their opinion, Mr. Burke was able to understand the nature and objects of proceedings against him and rationally assist in his defense. Therefore, they find that he is competent to stand trial. So, the court does find that Mr. Burke is competent to stand trial. Correct?
Yes, Your Honor. Does the court have orders from files? No. One of the city line out.
I don't have the orders, but I'm assuming everything else.
Yeah, actually, I can email them right now. Okay, just something like what Steve filed. I one for Kyle Charles.
Sending those to Ms. Adams or
Yeah.
so Ms. Adams, Ms. Arnold will be sending you the one for each file, and her will need 3 copies of each one to sign. So we'll need 4 total. One. Yeah, ouch.
Right out of the gate, the mental illness question sets the stage. In criminal law, this isn't about sympathy, it's about competency. Can a defendant even understand a trial? That's the difference between standing trial or heading into psychiatric evaluation.
Then we do not stimulate the energy of all those reports. Is that correct, Mr.
That's correct, Your Honor. And I did meet with Mr. Burke at the Lenawee County Jail, and I advised him of that.
Yeah. The original. Are those originals tonight? Okay. Your state, do you want these? Oh, rotate around. All right. So, Mr. Burke, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth? Yeah. Okay. So I'm going to need you to speak up a little bit louder for me. Can you repeat your response again?
Yes.
All right, excellent. Can you state your full name, sir?
Joshua Jordan Burke.
Okay. So, so Ms. Lamont, your client is today going to enter a plea of no contest.
Correct, Your Honor. That's what we
Then
discussed.
there will be a finding of not guilty by reason of consent, correct?
Yes.
No contest. Okay. All right. So, Mr. Burke, you've had an opportunity to speak with Ms. Lamont. She said she came and saw you, and you've had time to. Is that correct?
Yes.
All right. Are you satisfied with Ms. Lamont as your attorney and the advice that she has given you?
Yes, so far.
All right. Now, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest, and I think phrase it to a plea of not guilty by reason of insanity on each of these files? And which counts are you going to be pleading to?
All counts.
All counts, but no habitual offender?
No.
No habitual offender. So that would be count 1 and 2. 1, 2, and 3. Look, count 1, 2, 3. So, all right. So, Mr. Burke, you understand that on file number 24-21879SC, you're pleading no contest to a plea of not guilty by a reason of.
Notice how carefully the judge is walking through this report. This isn't casual paperwork. Competency hearings are a safeguard to ensure due process. If a defendant can't grasp what's happening, the trial itself could be unconstitutional.
And or a $1,000 fine. Count 2, assault of a prison employee, carries a maximum penalty of up to 5 years in prison and or a $2,500 fine. The habitual offender for offense notice would be dismissed. On file number 24-21878FH, you'll be entering a plea of no contest to not guilty by reason of insanity to count 1, home invasion first degree, which carries a maximum penalty of up to 20 years in prison and or a $5,000 fine. Count 2, second degree arson, which carries a maximum penalty of up to 20 years in prison and $20,000 or more restitution. And count 3, assault with dangerous weapon, felonious assault, which carries a maximum penalty of up to 4 years in prison. And then on file number 24-21880, you'll be entering a plea of no contest to a not guilty by reason of insanity to count 1, police officer assaulting, resisting, and obstructing. Count 2, police officer assaulting, resisting, and obstructing. And count 3, police officer assaulting, resisting, and obstructing, all of which carry a maximum penalty of up to 2 years in prison. So, do you understand? And is that your intention to plead no contest? to a not guilty by reason of insanity on each of those files?
Yes.
Okay. And again, you're satisfied with Ms. Mon as your attorney and the advice that she's given you? Right. Neither the prosecutor, the defendant, nor anyone else in the defendant has discussed the possible steps with the court that correct Ms. Earl in terms of what will happen with the president.
Yes, I'm happy with that.
Yeah, okay. So you understand, and the process for this would be once the plea is entered, or the process through the forensic center of the state of Michigan. Is that correct, Ms. Arnold?
Yes.
So we have no determination, Mr. Burke, on how long you would be placed with the Department of Corrections at the forensic center, or what the outcome of that placement in the forensic center would be. Do you understand that, Mr. Burke? That would be
Here's the twist. Competency is about now, but criminal responsibility is about the time of the crime. Two very different legal standards. Competent today? Yes. Criminally responsible back then? That's a whole other debate.
to the staff of the Center for Forensic Psychiatry. Do you understand that?
Yeah.
Okay. Anything to add to that? Ms. Dumont, anything to add?
No, yeah.
So this court has made no promises to anybody about what will happen there, because it would be under the authority of the Center for Forensic Psychiatry. Do you understand that, Mr. Burke?
Yes.
So if a no contest plea to not guilty by reason of insanity is accepted, there will be no trial. This means that you're giving up rights you would have had in a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial. The prosecutor and court agree to have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Mr. Burke, that if your plea is accepted, you may be giving up their right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that, Mr. Burke?
Yeah.
Do you understand that any appeal from the conviction is sensitive? What? Oh, do you understand that? If you had gone to trial, you would have had an automatic right to appeal to the Court of Appeals, but by entering the plea, you don't have that automatic. Do you understand that, Mr. Burke?
Yes, I said yes.
Oh, okay. I thought you did. Okay. You understand that any appeal to the conviction pursuant to the plea will be by application for leave to appeal and not by right. Do you understand that?
Yeah.
Do you understand that if the plea is accepted and you engage in any misconduct, it doesn't really apply to you, but do you understand if the plea is accepted and you engage in any misconduct as defined in NCR 0.310, between now and sentencing, the court will not be bound by any sentencing agreement or evaluation. You will not have a right to withdraw your plea. Misconduct is defined to include, but is not limited to, absconding, failing to appear for sentencing, violating terms and conditions of bond, or the terms of any sentencing or plea agreement, otherwise failing to comply with the order of the court pending sentence. And Ms. Adams, can you make sure the jail gets a signed copy of the advice of rights from him? So, Mr. Burke, you are not a citizen of the United States of America. A conviction of crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions, Mr. Burke, about the rights that are given to you?
No, Your Honor.
So I think it would be phrased, Mr. Burke, so you're going to be entering a no contest plea to not guilty by reason of insanity. So I think your response on this one would just be either, well, no contest. That's what you wish to do, okay?
Thank you.
So how do you wish to plead to the charges that on or about February 2024?
Whoa, pause here. These charges are serious. Prison assault, arson, home invasion, Each one could stack up decades behind bars. But the insanity plea acts like a legal reset button. Instead of punishment, it pivots the case toward treatment.
That's 218788. How do you wish to, right? About 24-21878. How do you wish to plead the charge that on or about January 11th, 2023, Madison Township in the county of Lenawee, that you did commit the offense of home invasion versus no contest to, but not guilty by reason of insanity?
Yes.
Okay. And how do you plead count 2 on that same date, time, and venue to second degree arson?
Right.
Not guilty by reason, or no contest to not guilty by reason of insanity. Is that correct?
Yes.
Okay. And then on count 3, assault with a dangerous weapon for that same date, time, and venue. How do you plead on that one? Not guilty by no contest to not guilty by reason of insanity.
Yes.
Okay, I'm sorry. That's a mouthful. All right. Then we're going to move on to file number 24-21879. So, Mr. Burke, how do you plead to the charge that on or about February 7th of 2023, in the city of Adrian, in the county of Lenawee, that you did commit the offense of jail, possession of a weapon, and do you wish to plead no contest to not guilty by reason of insanity on that file?
Yes.
And then on count 2, assault of a prison employee, do you wish to plead no contest to not guilty by reason of insanity on that?
Yes.
Okay, and let's move on to file number 24-21880F8. Mr. Burke, on that file, how do you wish to plead to the charge that on or about December 28th of 2023 in Dover Township, county of Lenawee, that you did commit the offense under count 1, police officer assaulting resisting obstruction? How do you wish to plead to that? Do you wish to plead no contest to not guilty by reason of insanity? Okay, and on count 2, police officer assaulting resisting obstructing. How do you wish to plead to that one? Do you wish to plead to no contest to not guilty by reason of insanity?
Yes.
Then on count 3, the same charge, police officer assaulting, resisting, or obstructing. How do you wish to plead to that charge? Is that also a no contest to not guilty by reason of insanity?
Yeah.
Now, Mr. Burke, you understand your options were on all of these: plead guilty, not guilty, or the no contest to not guilty by reason of insanity. Is that correct?
Yes.
And on all of these counts, on all 3 files, your choice was to plead no contest to not guilty by reason of insanity.
Yes.
Mr. Mott, that's due to mental illness, lack of memory.
Mental illness and lack of memory.
Is that correct, Ms.
Yes.
Arnold? Okay. So, has anyone made any threats or promises to you to induce you to plead no contest to not guilty by reason of insanity on any of these files?
No, they haven't.
All right. Do you understand that if I accept these pleas, you will be giving up any and all claims that your pleas are given as a result of promises or threats that were not disclosed to the court in the record during this hearing, or that it is not your own choice to do the plea? Do you understand that?
Yes.
Prosecutor or defense counsel where promises or threats and inducements other than a plea bargain to induce the defendant to plead no contest to not guilty by reason of insanity. Mr. Arnold and Ms. DeMont.
No, Your Honor.
Right. So, Mr. Burke, we touched on this slightly already. Obviously, the authority of what happens to once you go to the forensic center is within their purview. So, your attorney hasn't promised you any particular sentence or estimated how long that term will be or what will happen then, has she?
No.
And is it your own choice to enter all of these to no contest to not guilty by reason of insanity?
Yeah.
So, Ms. Harold, I have felony information from this file as well as criminal responsibility report. So do you want me to findings of criminal responsibility?
Judge, I can put on.
Okay.
There's a report authored January 27, 2025. The doctor who involves psychology, a licensed psychologist, and examiner here. He spoke with the spoke with the attorney, did all police reports, as well as several mental health doctors. He authored a comprehensive report of all his findings relative to all the charges and his criminal responsibility opinion stated, in my opinion, I'm mentally ill. I'm of all three alleged indigent offenses. Here's also my opinion as a result of his mental illness. He lacks empathy to appreciate the wrongfulness of his conduct or his conduct in the performance of law. It is therefore my opinion that will make me statutory record.
All right, and Ms. Mott, you also received that report?
Yes, I have it.
Okay, and you also agree that he was mentally ill at the time of the offenses. As a result of that, he lacked substantial capacity to appreciate the wrongfulness of his conduct and conform his conduct to the requirements of the law.
Right.
All right. The court will find then that he was overdosed out and statutory requirements for the Constitution.
And I'll get the book. I'll probably use it for all of our
We start with 24-20.
Starting with that file, there's a police report from the Illinois Sheriff's Department, report number 23-00072, which is exhibit number 2 of the settled record. According to that report on January 1st of January 11th, 2023, Madison Township, County, State of Michigan, individual by the name of Aaron Lopez, who was at her residence in Madison Township. The defendant went to the window of a residence who was for a female. There was a brief conversation outside. She had to leave. People like flare guns through a window and her phone was on fire and places the home from the window. I believe that support conversation. First degree in that he did honor dwelling while she was present in that while and husband were acting to commit arson. Of course, the second degree arson in that caught a fire the living room. So it did willfully maliciously burn, damage, or destroy that fire. By the dwelling or contents itself was a dangerous weapon in that she was placed in fear of harmful assault by the flare gun from it launching to the adult and actually followed the fire.
So you fired it through the window.
People fired it through the window and broke through the window.
All right, Ms. Mott, do you agree to that recitation of fact?
I'm satisfied, Your Honor.
So I'm found number 24-21878.H, based upon the facts placed on the record and from the information contained in the police report as provided to the court and to Ms. Mott, the court finds beyond a reasonable doubt that on January 11th, 2023 in Madison Township, County of Illinois, that the defendant did commit offense listed under count 1, home invasion, first degree, that he did use a flare gun to break a window and then enter without permission the dwelling located at 129 North Street. Then upon entry of that, did commit the offense of second-degree arson. That dwelling was lawfully was occupied, and the occupant was lawfully present. And by firing the flare gun, he did cause a fire to start with, and did willfully damage or destroy by fire dwelling or contact. Count 1 and 2, and then.
Did you catch that hesitation? This moment highlights the delicate balance. The judge has to confirm that the defendant truly understands what rights he's giving up. If there's any confusion, the whole plea deal could unravel.
While firing the weapon into the building and in the building, did make an assault upon ML with a dangerous weapon without the intent to commit crime of murder or to inflict great bodily harm. but it was assaultive in its nature, and therefore the court satisfied with count 1, 2, and 3, the factual basis, and the court will accept no contest plea. On that file, it has applied with MCR 302 seeing the referral. Yes. Yes.
Yes, sir.
Okay. The one that follows is claim for F21879 F8.
This factual basis comes from my for 23 years of 1504 versus for the challenge to provide the federal record. According to that report, I have also your son 2023 city of Adrian, Idaho County, Michigan. While the defendant was incarcerated in Kilo County Jail, he did possess and was instructed by Sergeant and were having a toothbrush final to the sharp point and a stabbing tool. While he had a toothbrush, he had a conversation with corrections officer Buford, who was the employee of Langley County at the jail. While he was there, and during the conversation, he directly pointed it to her afterwards, threatening to kill her family, or close to her, and pulled the toothbrush fashioned as a weapon.
That is straight out of a movie, but terrifyingly real. A flare gun turned into an arson weapon during a home invasion. This dramatic detail is exactly why juries have such an emotional reaction and why insanity defenses get so heavily scrutinized.